This is the second set of slides for part 3 in media law, and it's talking about protecting confidentiality, protecting sources, and whether there is such a thing as reporter's privilege. So this is something that's come up since throughout the history of journalism, and it especially relates to journalism in the US because whether or not reporters have a privilege that is above and beyond that of normal citizens. Now, generally, the way that the courts have ruled is that reporters do not have privileges that general citizens don't, especially when it comes to whether or not they have to disclose their sources to the courts, and basically whether they're above the law when it comes to reporting on things that they witness and, the people that they've interacted with. Because you think about it, sometimes in order to cover these big stories, sometimes maybe you have to be leaked information, or you've been given information that has been gotten through ill-gotten means, or perhaps you witness a crime in the purposes of your news gathering. And do you have a responsibility, and can you legally be held accountable to the courts in order to disclose this information, especially since part of the way that anonymous sources will come forward is if they're guaranteed their safety. You wouldn't come forward to a reporter and tell them something that could land you in jail or could cost you your job if you're a whistleblower, if you thought that reporter was going to give you up. So there's an ethical responsibility to keep the confidentiality. Is there a legal responsibility? So there's two cases specifically in the 70s that show that you are legally required to follow the law if you are a journalist. And in fact, people have gone to jail for protecting their sources. And that it is one of those things which is a ethical obligation to your source first and foremost. And then, there are legal ramifications. So there's specifically the two that your book points out. We've got Brandenburg versus Hayes, and it shows that journalists do not have the right to refuse to reveal their anonymous sources, especially in grand jury testimony. Now, one of the things about Brandenburg versus Hayes that I'll get into in a second is that it was very specific, and that's the one thing about all these Supreme Court rulings is that they are very specific in their application, so they can then be kind of applied differently depending on who's applying them. And Hutchins versus QQED, journalists don't have any special rights to access federal prisons. We'll get into courts in the next section. But one of the things, in Brandenburg versus Hayes, I wanted to point out is that, well, one, this is the only case that the Supreme Court has ruled on reporters' privilege in. They have ruled on other things that are related, and they've refused to hear cases that touch on reporters' privilege, but they've ruled in this one specific case. In a 5-4 decision, the court ruled that journalists who witness a crime are not immune from grand jury subpoena and must testify what they observed and where they got their information. The who witnessed a crime is very important here, and this came up both in terms of the decision in favor. The 5, I wasn't unanimous in terms of that majority. There was one person who agreed but wrote a separate rationale for why they agreed, and at times, for a certain period of time, that agreement was actually seen as agreeing more with the dissent than with the agreement. And then the dissent was written basically saying, in this case, this person witnessed a crime and that's why. But if there wasn't a crime, then no, they don't need to give up their source. And there's basically a test that Justice Stewart put forward in terms of, there's the weighing back and forth between the judicial system and the importance of the freedom of the press. So the court ruled that the First Amendment freedom of the press did not include the right of reporters to refuse to appear before a grand jury and answer questions specifically about criminal activity that they witnessed. And this was that person who thought, yes, these guys do need to go and they do need to testify, but specifically because they witnessed criminal activity. If there had not been criminal activity involved, the 5th justice of the 5-4 thought that he would have ruled in a different way. The majority held that the public's interest in law enforcement outweighed the concerns of the press. So basically, they're weighing up two public interest issues: law enforcement and freedom of the press. And they said, well, the law enforcement, the fact that you've witnessed a crime, that outweighs. Because basically, if a court can't compel a citizen to testify, then the court loses its power. The only power that a court really has is because the public believes in it. So if we don't have that belief, then and we can't compel people, then we lose our power, and so that outweighs the freedom of the press. The majority opinion's rationale was that the proposed reporter's privilege, a reporter's privilege being their privilege to protect their anonymous sources, would differ for other privileges that the law recognized. So the law recognizes like client lawyer privileges, doctor-patient privileges, and in these cases, this is designed to protect a client, whereas in this case, it's protecting a journalist from jail. Now, the court also reasoned that the decision that they set down should not discourage Congress passing a federal shield law or states from creating statutes that shielded journalists from having to disclose this information. And state shield laws are the way that ended up happening. Most states have shield laws that protect sensitive sources, but federally there is no shield law. So you want to protect your sources as much as possible. So again, this is something where like if the FBI became involved, the CIA became involved, or you were called before a federal grand jury, or you were called before Congress, there is nothing that would shield you and allow you to basically claim reporter's privilege and say, I'm protecting my anonymous source. There have been efforts for a federal statutory privilege, but one of the things that it hinges on is that part of the First Amendment is that the government cannot license journalists. So how then would you determine that someone is a legitimate journalist, especially like in this age of citizen journalism? So by saying, listen, we can't license journalism, and part of that is so that there is more freedom to the press and that the press is, wider, that kind of makes it hard to then enact a federal shield law. So this has come up, probably the biggest thing, and like there's probably two ones that people like cite over and over again in terms of confidentiality of sources. One is Deep Throat, which Nixon Watergate, if you watched All the President's Men, or read the book by the same name, or just know Watergate, you know that there was a anonymous source who tipped off Woodward, and they, used that in order to uncover the issue, and the break into the Watergate Hotel and the stealing of information and the trying to destroy information, and they never disclosed who Deep Throat was, the two journalists who were involved. Unfortunately, I can only remember Woodward's name right now. It was only revealed by the family of the source when he was old and was going to be passing soon and felt like he should get some recognition for what he did. The other one in more recent memory, although it's you guys are probably a little young for it, is Valerie Plame. She was a CIA operative who is married to someone who had an ambassador post, and it was published in the press about the fact that she was a CIA operative. And the important part was that someone in the White House had leaked this information. It is illegal for a federal employee to disclose that other people are undercover CIA operatives for kind of obvious reasons. And in fact, a journalist was jailed for 85 days to protect her source. And eventually the sources, actually it was two, came forward themselves and said, we were the ones who leaked this, in order to basically discredit her, and to kind of force them to, basically protect themselves. And basically the reporter who went to jail for 85 days said, why would anyone come forward and be a source if they couldn't trust journalists to, in fact, honor the confidentiality? So while in most states, but obviously not all, there are still some states that don't have shield laws. In most states, you don't have to disclose your anonymous sources. If it's something that becomes of wider interest to the rest of the nation and becomes an issue that is something that becomes a federal issue, then it is possible that you would be called to court and compelled to disclose your source or go to jail. And it is very much considered, imperative that even if you are faced with jail time, you protect your source above all else. So in the next section, we're going to talk about courts and our access to those, and that will be section 4.